The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. I'm Richard Dietz. Joining me today are my colleagues, Judge Fred Gore and Judge Jefferson Griffin. We have two cases on the calendar this morning. The first is number 20877, Fearrington versus City of Greenville. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
May it please the court, I'm Paul Stam to argue in this case. My partner, Mr. Gibson, will argue the Vitovas case. We worked on each of them together. I'd like to reserve 5 minutes for rebuttal. This is an as-applied challenge to the Greenville red light safety camera program. I'm going to rely on my brief for the procedural due process claim unless you have questions about it. I think the brief is adequate. I'd like to hit one, my article number 5, whether Pitt County is a necessary party right at the beginning, because Pitt County, this should not take long at all, because Pitt County says, the Board of Education says, what did we do? All we did was take the money, and they should only be involved, if anything, in our challenge to the roughly 71% to return to the Board of Education rather than, as we claim, 90%. First, there are two reactions to whether Pitt County is a necessary party. One is a thought experiment. Suppose we had left out Pitt County in this case. Pitt County would certainly have had a right to intervene, not permissive intervention, but as a right, because it has a financial interest in the program, millions of dollars so far. Second, the Declaratory Judgment Act, under which this case is brought, specifically says that we have to make every person a party who has an interest in the matter. And of course, a financial interest of even a trivial amount would be sufficient. Here it's millions of dollars. I would like to go to the next issue, and that is the Chapter 89C, the engineering statute. And I would like to begin with another thought experiment. If Mr. Gibson wanted to give me a piece of property but wasn't around the day the deed was prepared, and he just told, to the secretary, sign my name. And then that secretary went to the notary public up front and said, Mr. Gibson says to notarize his name. Would we have any doubt that that was an invalid transaction to convey property? No. Substance over form. That's what's involved in this first argument. Greenville says, Mr. Renenbaum signed and sealed the engineering plans upon which this whole program is based, and without which it wouldn't work. But it's admitted the licensing board for engineers and architects has already sanctioned the people who actually prepared it, American Traffic Solutions, who is not a registered engineer. They're the ones who prepared it. Mr. Renenbaum signed it, although he was sanctioned by the same board for not actually preparing it under his direct supervision.
Well, I understood the primary argument that I think your friend for the appellee is going to make to be, to take your hypothetical, is that when that transaction occurs with that deed, there's another neighbor who looks at that property and says, I don't like the person that's living there, and digs around and says, well, you know what, this deed, there's problems with this deed. So you show up and say, I don't actually think you own this property, you need to get out. And so I think the argument your friend for the appellee is going to say is just like that person who really has no standing to come in and make the argument. There are other parties that would need to enforce those defects, if in fact there were any. That's the problem here, is your client's just not the right person to come in a cause of action and assert that these problems exist. So what's your response to that?
Well, my clients don't have standing to sue the engineer or to prosecute them, but my clients do have standing because the statute specifically says, and it's way down in the, I'm sure you found it, it's in the text of the statute way at the bottom, that every political subdivision has a duty to enforce it. And in this particular case, it's because they did not enforce that in conjunction with our argument a little bit later on substantive due process, that we're even here and that my folks receive citations. So whether you consider that a separate claim or part of the reason why the plans are so faulty is up to you, but the plans are not prepared and used according to law, and this is true even though we brought this to their attention years ago. They're still using the same, well, at least as of the date that the appeal was taken, they're still using those same faulty plans and making money off of people who inadvertently drive through. And I'll get to that provision in just a moment.
So, counsel, just to follow up on that issue, I'm trying to follow it to the end result of what remedy would then result. Is it that there's a, basically, they cannot prosecute individuals for that anymore? Or what remedy is available to your clients in that theory that you've presented?
Well, in this theory, the remedy is to stop the program until they have plans that have been really sealed by a real engineer who actually did the work.
I think
That
Judge
would be-
Gore's point is there some redressability element for your clients who have already received the citation, have gone through the process? So in other words, it could be forward-looking, that you can force these public officials to have to go and do what you say is their job to see whether or not there's a problem here with these the engineering licensure and things like that, but that the relief you're seeking, if it's backward-looking, isn't available, and so your clients are not the right parties to be here seeking relief.
Your Honor, in this whole sequence of litigation, it started out pre-enforcement, and Mr. Malmrose's case, pre-enforcement, was dismissed because he had not gotten a citation. We could have appealed that, but it was a lot more expeditious to just wait till someone who did not have that problem. So we brought this to their attention for years. I think that's the best answer I have. If I can now go to the experts, and there's a dog that hasn't barked in this case, and that is there's only one expert, and that's Brian Ceccarelli, who has a 19-page original affidavit, I think at 106, and a much more concise 4-page affidavit with attachments, a supplemental affidavit. And Greenville presented as a witness Chief Holtzman, but Greenville says he wasn't even testifying as an expert. So there's only one expert, which to me on summary judgment means you take it as true. And what he says in his affidavits is that and by the way, his qualifications and all the things that he looked at are in the original affidavit. The more concise one was a supplemental affidavit after the Institute for Traffic Engineers finally admitted that the equation they'd been using for decades was wrong. Now, probably y'all are better physicists than I am, but let me briefly explain the two major reasons why they're wrong. And he lays this out in great detail in his affidavits. First of all, if I'll just step back a little bit, and if I had two vehicles go into an intersection, this vehicle is going to go straight through. This vehicle is going to turn left. So they're coming along like this. Obviously, this vehicle will be traveling, say, 45 miles an hour. This one, to slow down, takes longer to get there. So the lights, as he mentions in his affidavit, using the figures from Greenville, should give the left-turning person more time to enter the intersection. But just the reverse. The intervals are longer for the person going straight through than the ones turning. It's backwards. Second thing, and this is the dilemma zone. It doesn't mean that everybody hits this dilemma zone, but a certain percentage of drivers, as they come up to any red light, and by the way, on page 9 of my original brief, I have a typo where I call the red light when I should have said yellow light. Hope that doesn't confuse you, my error. There's a certain distance at which, if you are driving the speed limit and intend to obey the law, you're in what's called the dilemma zone, at which, because of how these plans are drawn, you either have to speed up, possibly above the speed limit, to get through the intersection, or you have to slam on your brakes when you're close to the intersection to stop. That's called the dilemma zone. And what Mr. Ceccarelli testified to, and this is uncontradicted, is that under Greenville's current situation, that 80 to 90% of the drivers who are cited by Greenville, who pay the $100, are innocent under any fair interpretation of what innocence means. And I'll say what I mean. I'll come back to that. I'll come back to it right now. The criminal law of red light camera running has, as an implied adverb, willfully, and that's the backup mens rea for I think maybe it's an infraction now, but it was originally criminal. And willfully has been interpreted many times as meaning intentionally and without justification or excuse. So, and on the citation that is used by AOC, and this is attached to our brief, willfully's there. They're charged with willfully, that is intentionally and without justification or excuse, going through a red light. Well, both of these gentlemen tried to explain to the administrative hearing officer in great detail, and I'm not using this to argue the due process issue. I think that's explained well enough. But it's Exhibit K to the complaint is Mr. Malmrose's attempt to explain to the hearing officer what was wrong with their lights. And if you recall from the record, the determination was made by the hearing officer, fast yellow light. Yes, it was fast. That's what he argued, and that's what the hearing officer found. But he's guilty anyway. What was the point of the hearing? But the point was these guys tried to present this defense all the way up that they were really innocent, and in Mr. Ceccarelli's professional opinion, that 80 to 90% would have included Mr. Farrington and Mr. Malmrose as people who would not be cited under correct application of physics. He also makes the point that these principles of physics that he uses in his affidavit, and if you look at the supplemental affidavit, the old equation's about that long. The new one that's been adopted by the Institute for Traffic Engineers is much more nuanced, longer, and they would just be innocent. They would not be cited by a police officer who was standing there, because the difference would have been in the blink of an eye, imperceptible. And yet, 80 to 90% of the money coming in is from that type of situation. I think I better...
So I'm clear, This evidence, what claim do you say this supports? Like, why is this evidence relevant to your case?
It's relevant because of the section in our brief that there is a fundamental state constitutional right to intrastate travel, which is subject to reasonable regulations, a Supreme Court opinion to that effect, and you are subject to reasonable regulations. The briefs of at least one of the defendants says, well, my folks just think they are entitled to run red lights. No, they don't think they're entitled to run red lights, but they're entitled to a fair notice of what a red light is going to come on and when.
So this evidence, in your view, is for your 14th Amendment right to travel claim?
That's right. That's right. And that is, again, because there's only one expert who's saying it's not a reasonable regulation of interstate travel if 80 to 90% of the people who get the citations are innocent. And that's the situation here. Now, the Supreme Court, in the case we cited on that fundamental right to intrastate travel, they did not uphold the claim of the defendant in that case because he wanted to be able to go to a particular park and enjoy a particular park, and for some reason he'd been banished from that park. That's not our case. My folks, they live in Greenville. Well, actually, one of them, I think, lives in the town next door. But they travel through Greenville all the time, and they don't want to be subject to inadvertent violation of a regulation that they would not be guilty of under the criminal law. Now,
so you brought up the
Yes.
administrative hearing. So once there was a determination by the officer they were responsible or guilty,
Yeah.
whatever the term's going to be for that. So what can they do beyond that? There's an appeal process for that?
yes, and Mr. Farrington did that, appealed to the Superior Court. Mr. Malmrose did not, and that was the tactical decision that we wanted one plaintiff that did and one plaintiff that didn't. And the Superior Court judge said you have met all of your administrative remedies and then dismissed the case. I believe it was a consent order.
How does the Superior Court judge review that appeal?
Well, on the record, as an appellate judge, not as a de novo. And the problems, as you can imagine, for most people, for a $100 penalty to pay a $200 filing fee, and then lawyers, of course, that's not really a realistic remedy anyway. But Mr. Farrington did it. And then by consent, I believe, all the counsel agreed and the judge held that he had exhausted his administrative remedies.
So he actually didn't look at a record or anything, he did that, it was just consensual that it was over. Is that?
In Mr. Farrington's case, there wasn't much of a record. Now, he presented materials, but even though he presented them, no defense. No defense. So, as an appellate judge, what do you do?
Did Farrington seek to record the proceedings?
No, Mr. Malmrose did. And
Right, so
his recording device was taken from him.
So the argument your friend for the appellee is making is that was something that Malrose had to pursue through the process that was sort of the equivalent of the criminal proceeding. So, the hypothetical that I want to ask you about that is, imagine we just had some very simple infractions where there was a similar administrative process created for just pick your minor, so-called offense. So spitting on the sidewalks or walking on the grass where it says do not walk on the grass here in the state property, whatever it is. And the state creates this process, administrative process, and they say, we're going to call this, the Star Chamber. And we're going to bring you won't be able to have a lawyer. You won't be able to cross-examine witnesses. You won't do any of these things. And you have to go to the Star Chamber and they say you got to pay the fine. And then you just give up and turn around and file a deck action and say the process is unconstitutional. I guess the question is, in your view, can you do that?
Yes, and if I recall, the Declaratory Judgment Act, either by statute or by case law, says that another remedy is not a defense to Declaratory Judgment Act.
But don't you run into the problem that our law typically doesn't allow you to collaterally attack a criminal judgment by claiming in a separate civil proceeding that process violated, some due process clause or something like that. We have criminal process and then we have post-conviction relief.
Your Honor, two things. One, this wasn't a criminal action.
Right, I'm just using the analogy because it's similar.
But two, I think that if we did that, the citizens would require that law to be abated as a nuisance. And I'm actually quoting the state Supreme Court and in cases involving not allowing willfulness as a defense to a criminal case. I can't remember the case right now, but I've quoted it often enough that the law should be abated as a common nuisance if it didn't allow for that defense.
But I think your friend for the appellees would say it did allow for the defense. You just raise it in your case, and then you appeal to Superior Court, and you say, this process is a kangaroo court. They wouldn't even let me record it. You need to declare this a violation of due process, and the Superior Court could do that on direct review. But if you don't do that, you can't come in later and collaterally attack it. That's, I think, the argument your friend for the appellee will make.
That's their argument. A Superior Court judge did refuse to say, dismissed our claim for procedural due process. It wasn't, but there, the judge was a fact finder as well, which is much more likely to get to the truth than if the Superior Court judge is just acting as an appellate judge. If I could be sure to get to at least one of the most important arguments, and that is, what happens to the money? There are lots of figures in the briefs. The long story short is that Pitt County Board of Education is receiving about 70% of the penalties, not fines, penalties. There's a statute that says that implements the constitutional provision that says that it has to be 90%. There have been other local bills. I believe this is Wake and Concord, if I read the Shavitz case right, where the General Assembly said, well, you can deduct this, and this, and the rest is clear proceeds. That is not this case. This case says, this local bill says, you can make an agreement as to cost sharing. You can have an interlocal agreement. We've never disagreed with that. If ATS wants to advance the money to put up the signs and the cameras, that's fine. But nowhere in that bill does it say that Pitt County Board of Education can get less than 90%. Now, their defense is, oh, we got 100% from the city of City of Greenville Police Department. So what's the problem? Well, the agreement also says that the Pitt County Board of Education will pay invoices for the cost to ATS, and the result is they get about 70%.
So suppose you're correct about that. What's the remedy?
The remedy is to stop it and for Greenville to give the money back to the people they took it from.
So the remedy you're seeking is is a declaratory judgment that to move the money to the schools. That's what.
Well, to remove it from Greenville. Now, in our prayer for relief, we may have asked for a refund from both of them. Of course, we're not bound to what's in the prayer for relief, and it might be better if just Greenville did it and leave Pitt County with what they already have. That's between them. Pitt County was taking the money, knowing of all these problems, knowing of the challenges, and yet there they have it. Now, their main argument on that is at least we get 70%, whereas what you would say is we get nothing. Well, many times in the law, there are limits on what can be received, like usury. Let's just take usury, for example. You know, sometimes people pay 2%, 5, 10, 15, 20, 250% for payday lenders. But the law says for certain transactions, the only thing that's fair and legal is a certain percent. And the General Assembly says, unless we say differently, the only fair thing is you get 90%. That's not my opinion. And if they want to change it so that thereafter Board of Education gets 90% and Greenville actually pays for law enforcement. I mean, this whole scheme is basically Greenville saying, well, it's not worth stopping red light runners. We're not going to pay a dime for it. But if we don't have to pay anything for it, we'll go along with this scheme. It needs to stop. Thank you very much. I'd like to reserve the remainder of my time.
All right, thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court, my name is Robert King. I represent the Pitt County Board of Education in this matter. I'm joined in that representation by my friend and partner, Elizabeth Troutman, by agreement with counsel for the City of Greenville, Mr. Hartzog. I will go first. As a preview, Ms. Troutman will be arguing the second case on behalf of both the county and the Board of Education. I should note that in the courtroom we're joined by the General Counsel for the Pitt County Board of Education, Ms. Emma Hodson, the City Attorney for the City of Greenville, Emmanuel McGirt, and the Chief of Police for the City of Greenville, Chief Mark Holtzman. Plaintiff pled 5 claims against the Board of Education. And in all of those claims, the plaintiff alleged not that we were simply necessary parties, but that the Board of Education affirmatively violated the constitutional rights of people who would run traffic lights. As noted in our brief, plaintiffs have abandoned their second cause of action, so that leaves the first, third, fourth, and last cause of action. I would like to focus primarily on the third cause of action under Article 9, Section 7, but I would like to briefly address the others before I yield the podium to Mr. Hartzog. I think it is not just appropriate but helpful to actually say what it is the plaintiffs are arguing here in clear terms. Plaintiffs contend that by virtue of the plaintiffs having done something both illegal and dangerous, running traffic lights, they can come into the courtroom and argue that the Board of Education, which is the intended recipient of monies protected by the state constitution, is in fact acting illegally because the Board of Education is not getting enough money, and that the remedy is that the Board of Education pays the people that broke the law millions of dollars. That's the remedy. That's what they're seeking in this case.
Well, I actually didn't hear your friend from the appellant say that. That was the question I'd asked. So wouldn't the remedy be either a declaration or if there's some injunctive relief, it would move money around? So your client would get money. How is money going to the appellants in any of the scenarios of the claims that have been described here?
I'm going based on the complaint, Your Honor. And the complaint says that the Board of Education violated people's constitutional rights, that the Board of Education is acting illegally pursuant to a constitutional provision that is explicitly designed to help the Board of Education. And the remedy requested in the complaint, the only remedy requested monetarily, is that the Board of Education takes money away from the education of school children and gives it to the plaintiffs and their attorneys. That's what they asked for in the complaint. They've never asked for anything, or they've never changed that. The essential facts in this case are very straightforward. If I could address those briefly. The General Assembly authorized the Board of Education and the city to enter into a cost-sharing agreement where the Board of Education would receive at least 90% of the money that came in. In reality, they received 100% of the money, and then the Board of Education would reimburse the City of Greenville for this money that was spent, approximately 30 cents on the dollar. Here's the critical point. This is not an arrangement that was crammed down on the Board of Education. In every other Article 9, Section 7 case that you see, what you see is local units of government or the state of North Carolina ripping off the Board of Education. They come up with something. Now, if what the General Assembly had said instead was, Greenville can operate red light cameras and we mandate that the Board of Education must pay for that, that would be a violation of Article 9, Section 7. They were given the option, the Board of Education was given the option to enter into this agreement, and they like the agreement. They appreciate what the city is doing because it generates millions of dollars. Plaintiffs acknowledge that the city pays 100 cents on the dollar to the Board of Education. And what does the Board of Education do with that money? It goes into the local current expense fund, and they pay teacher salaries, they pay for chalk and erasers, they pay for school resource officers, the police officers that appear, they pay for insurance, and they pay to honor their contractual obligations, one of which is to the City of Greenville, that the Board of Education entered into voluntarily.
Counsel, on the issue, and you bring up the concern and the public policy perception of how it helps, right? What is your stance on the claim, on the argument and the claim that there could be 80 to 90% of these people being innocent and then being parents of children, hardworking citizens of the town, single parents, struggling, having to pay a $100 fine when they could be innocent? What is your concern from that claim in light of the necessity and the benefit that the school board is receiving? That is a viable and important claim.
Yeah, excellent question, Your Honor. I think the way to answer it is first say, well, what claim does that relate to? And I think the claim that relates to is the procedural due process claim. Judge Dietz, I think, hit the nail on the head here, which is you only have a procedural due process claim as an ancillary or collateral proceeding if you don't otherwise have a remedy. There is a remedy here. If you don't like the way the administrative process works, you have the right to go to the Superior Court on petition of writ of certiorari, and whether that is adequate to satisfy the requirements of due process has already been resolved by the courts in the matter of structural components versus City of Charlotte. This is dead law. I mean, it is law that has been decided, I think,
Does
quite
it matter that this isn't really a criminal proceeding? Because in the civil context, there are situations where you can bring a declaratory judgment action, challenge a law, although you could also violate the law and in the proceeding where you're, for enforcement, raise your constitutional challenge. And, I think what your friend for the appellant is saying, that's all we did here, is we have a number of plaintiffs. We brought a declaratory judgment action saying that this system violates procedural due process. We're just attacking that through a declaratory judgment action because it applies to all our members, prospective members of the class and so on.
I think it comes back to structural components versus the City of Charlotte. If the answer is that you are given a remedy, you do not have a procedural due process claim. Now, if the answer is, I don't like what a Superior Court judge does, so I'm going to go sue the people that are involved, we better hire more judges, because that means you can file a collateral action every time you don't like what a Superior Court judge does. What plaintiffs are complaining about is that they lost. Well, half the people in every case lost. That does not mean you've been denied due process. You're not given the right to win, you're given the right to argue. And they were given the right to argue.
But my question was, so suppose we accept that. They lost. They got these citations, they paid their fines and everything, and then they turn around and say, but you know what, I could get another ticket at some point. So, and this law is unconstitutional. It's a kangaroo court, so I'm going to bring a declaratory judgment action. Why can't they do that?
Because they have the right to go to the Superior Court, and they have the right to go from the Superior Court to the Court of Appeals. If the situation was different, Your Honor, and the only remedy was this ad hoc administrative process, I think that would be a good argument that there will be a problem with that, because you're being denied access to the courts. But every plaintiff in this case is given access to the courts every single time that they got a ticket.
Yeah, I guess I'm not doing a good job, I think, explaining the point I'm making. So imagine, take it out of this procedural due process context, put it in, let's say, the First Amendment context. So, they've just said we're not going to allow you to make this particular, it's a obvious viewpoint discrimination. We don't like your particular type of protest, we're not going to let you do it here on public property, and, you do it anyway, you get some sort of citation, and you never raise the First Amendment argument, and you end up paying it, and so on and so forth. And then later you think about it and say, this is unconstitutional. And, I may want to protest again, so put standing issues aside. Let's say you can clear that hurdle. Why can't you just come in like you could in the First Amendment context and say, this policy is unconstitutional.
Because I don't think you can put standing aside, Your Honor. I think, because if you don't have standing, then every person that wakes up on the wrong side of the bed and happens to have a law degree can go out and cause trouble for whatever government entity they want to. You have to have standing. You have to have an injury. If you have an injury and you're being denied due process, then you follow that. If somehow you're being denied due process and you have been injured, then perhaps you have your own action that you can bring.
So your position is, if the state of North Carolina really did create a new star chamber, the only way we could challenge it is have somebody have to go and walk in front of the star chamber and go through that process and then argue on appeal. This is blatantly unconstitutional. There's no way to file a lawsuit and be like, this should be obvious to everyone. You can't have this type of kangaroo court. You don't think you can do that in a DJ action?
I don't think you can do that if you have the ability to get to the Superior Court. Because otherwise what you're saying is that the Superior Court and the Court of Appeals and the Supreme Court are part of a kangaroo court process. If you could not go to the Superior Court, I think there'd be a problem with the process. But I think this was built in specifically to address issues about procedural due process. And again, the court in structural components has already said this type of process, in fact, provides due process. If you were given due process in the primary proceeding, no, you should not be able to go out and file an ancillary action, because then you're going to have endless litigation. I think that's, as much as anything else, a question of judicial efficiency. If I could, I'd like to turn briefly to the issue of Article 9, Section 7. There are multiple reasons why the argument that's being raised by the plaintiffs are incorrect, and if I could walk through those briefly. First of all, you've got the plain language of the Article 9, Section 7. What does Article 9, Section 7 say? It says that the money that is raised from fines and forfeitures has to be appropriated to the Board of Education. The City of Greenville has to hand the Board of Education at least 90 cents on the dollar, and that's exactly what they do. Now, the argument is that somehow this is subterfuge. Well, it's not subterfuge unless you're being injured by it. Now, who's being injured here? And let me put it a different way. What is the intent of Article 9, Section 7? Every court that has ever looked at it has said the purpose of Article 9, Section 7 is to give money to the Board of Education. And that is exactly what's going on here. Again, it would be different, and we've seen other counties do this. I'm going to talk about the Shavitz case in just a minute, where they cut the Board of Education out of the loop and take money away from the Board of Education before it ever gets to them. The argument that we only keep 70 cents on the dollar, well, you know how much the Board of Education keeps of every dollar it gets from every source? It keeps zero. We spend the money that comes in because it is expensive to run a school system. Some of it goes to the City of Greenville for the red light camera program. Some of it goes to the City of Greenville for SRO. Some of it goes to pay the teachers. We don't keep any money. We are not a for-profit organization. We don't distribute money to shareholders.
Right, but you do see their argument, right? Because all you have to do is change it from 70% to 1%, and then you can see the problem, which is that what essentially happens then is that the fines are going to a fine factory in a private company to operate it, and you can imagine the framers not having that in mind. What they wanted is to know that if there's a fine that's imposed, that the money goes to the schools. And the money would not be going to the schools here. It would be going to fund this ongoing operation of, having more fines. So if you, and what's the difference between 70% and 1%?
I'm tempted to say 69%, but that would be a smart alecky response, Ron. I understand exactly what you're asking. Let me make a couple of points about this. The overwhelmingly important point here is that the school system has agreed to this. The school system has looked at the situation and said, would we rather have zero or would we rather have 70 cents on the dollar? And the school agreed to this arrangement. This goes back to the issue of standing, or the issue of standing that I wanted to raise a moment ago, or want to raise now.
Yeah, but let me say that your friend for the appellant, their argument is, it doesn't matter if the school agrees to it, because we, the people, didn't agree to it. So the Constitution has a purpose, and here they're going to say the purpose is that when you collect a fine, that amount of money, your clear proceeds, go to the schools, and here you've come up with a clever way to make that not happen. Less than all of it is going, and really that 30% should be shifted back to the other parties to figure out how to pay that before you get the money, and that's just not happening. So what's your response to that?
Well, first of all, let's be clear. The plaintiff is not here to get more money for the Board of Education. The plaintiff is here, and in the other lawsuits, to shut down the red light camera program. And one of the ways they want to do that is to argue that somehow the Board of Education is being treated unfairly, even though the Board of Education says that they're not being treated unfairly. I think what Your Honor raises exactly the issue of standing, and raises the issue of the intent of the drafters. What was the purpose of Article 9, Section 7? The purpose of Article 9, Section 7 had one person in mind, and that was the Board of Education, to put money into the hands of the Board of Education. What the plaintiffs are arguing is that because they don't think we're getting enough money, they can come into the courtroom and take money away from the Board of Education. I think that is an absolutely bizarre outcome. There is no subterfuge if everybody agrees to it. Who is it that has the right in the situation? The party that has the right in the situation is the Board of Education. I've argued a lot of Article 9, Section 7 cases. I argued the Shavitz case that I'd like to turn to in just a moment. In every one of those situations, the victim was the Board of Education. The Board of Education, I'll talk about the Shavitz case for a minute because the plaintiff says the only difference between Shavitz and this case is the timing of the payments. That is absolutely incorrect. I mean, Shavitz could hardly be any more different except it addresses the same provision of the Constitution. In Shavitz, the city of High Point went out and started a red light program and just ignored the Board of Education. They just took all that money and stuck it in their pockets. Mr. Shavitz got a ticket. Mr. Shavitz sued because of a violation of his constitutional rights, which the court rejected, as the court should do here. And then they also sued the Board of Education and said, we need a DJ because we think that to the extent that this is constitutional, the money needs to be going to the schools. And I and the other school board attorneys looked at the lawsuit and said, you know, they're exactly right. We're getting ripped off by the by the city of High Point. So we filed a cross claim against the city of High Point. In every case except the ones the court's going to hear today, under Article 9, Section 7, the aggrieved party is the Board of Education. In this situation, the Board of Education is being sued because they're not getting enough money. I think that is just a bizarre concept. If I could, I need to yield time, but I do want to mention a couple of things. First, the General Assembly obviously authorized this. The General Assembly, according to the Constitution, has the right to provide this type of statute. When the General Assembly acts, as the court said in Kabul, the actions of the General Assembly have to be found to be constitutional unless it is against the plain language of the constitutional provision. The constitutional provision here says the money has to be appropriated. What we are talking about here and what plaintiff wants is the most naked and open form of judicial activism. They want the court to write into the North Carolina Constitution restrictions on how money is spent by the Board of Education. That is not in Article 9, Section 7. They want you to write something into the Constitution to take money away from school children because they want to shut down the red light camera program. I'm going to address briefly, if I could, the other 3 points or the other 3 arguments. I haven't turned far enough over here. So the first cause of action is that the yellow light interval is too short. You heard counsel argue about that quite a bit. The city, first of all, you will not find a teacher on a ladder installing a red light camera. Even though we've been accused of running this program, we don't run this program. All that we do is we get the money from this program. But since we've been accused of violating constitutional rights, I would like to say this briefly. The interval for yellow lights is set by the North Carolina and federal departments of transportation. Period. You don't like it, go sue NCDOT. Don't sue the Board of Education and don't sue the City of Greenville. Fourth cause of action is the use of an unlicensed engineer. The law is crystal clear that you do not have a private cause of action under a statute unless the General Assembly gives you the right to do that. The General Assembly, just like federal Congress, can create citizen suit mechanisms. There is a way to enforce this, and the way to enforce this, if you don't like what an engineer is doing, is that you go to the Board of Examiners of Engineers and Surveyors. They have enforcement authority. There is no citizen suit provision.
Well, your friend for the appellant says there is another option. The statute expressly provides that all public officials are required to enforce those provisions. I'm not sure how they would do it, but that they have to. And I think what your friend for the appellant is saying is we're just seeking a declaratory judgment to make these particular public officials carry out the requirements of the statute. Whatever remedy is there, it's not clear to me what it is, but I think that's their argument. So what's your response to that?
Well, my response is that it's not clear what the answer is, Your Honor, but what is clear is 2 things. The law is clear that you do not have a private cause of action unless the General Assembly says private citizens can file these lawsuits. And if the General Assembly wanted that to happen, the General Assembly knows how to do it because they've done it many times.
But if the state's violating the law, you can bring a declaratory judgment action and say you're violating the law, right?
You can, depending on the situation. But here is a situation in which the General Assembly says there is an explicit remedy, and the explicit remedy is you don't go to a Superior Court judge and you don't go to the Court of Appeals and argue with them about how engineering works, because we have a board of examiners. We have experts that deal with these situations. The last thing that I would mention is procedural due process. I've already covered this. That is, if you have a remedy, you do not have a due process claim. You cannot file a direct constitutional claim if you have a statutory remedy. There's clearly a remedy here, which is if you don't like what happened with the City of Greenville administrative process, go to the Superior Court. If you don't like what the Superior Court did, go to the Court of Appeals. With that, I have eaten into Mr. Hartzog's time, and unless there are any questions, I will yield the podium to my colleague.
All right, thank you, Counsel.
Morning, Your Honors. May it please the Court, Dan Hartzog, Jr. on behalf of the City of Greenville. I'd like to start by talking about 89C, the argument there. I would refer, Your Honors, to the actual language of the statute. What the statute says is the duration of the yellow light change interval at intersections where traffic control photographic systems are in use shall be no less than the yellow light change interval duration specified on the traffic signal plan of record signed and sealed by a professional engineer. And licensed in accordance with the provisions of 89C of the general statutes and shall comply with the provisions of the Manual on Uniform Traffic Control Devices. So essentially what that language does is says that the city is not allowed to have a red light camera system with a yellow light interval that is either less than the Manual on Uniform Traffic Control Devices or less than the plan signed by an engineer. That's what the statute requires. In North Carolina, and on these particular streets in the City of Greenville, those yellow light intervals are set by the DOT. The city has no control over the yellow light intervals. They are set, they're mandated by the DOT and by the Manual on Uniform Traffic Control Devices. So even if the engineer had said, you know what, I think you need to have a longer or a less, we would have to go to DOT and make that request for DOT to agree to change the yellow light intervals. The city does not control that, and that's a fundamental flaw in the plaintiff's challenge to the red light camera program. You know, you hear about, fast yellows and the safety zone and the danger zone to stop. All of that is the DOT's issue. And we've told plaintiff's counsel that, this is an interesting theory that the yellow light intervals need to be changed. You need to go to DOT because the city doesn't have any control over the yellow light intervals. Apparently, Mr. Ciccarelli has gone to the DOT, and it was unavailing. But the bottom line is the City of Greenville does not control yellow light intervals. The red light camera program did not change the yellow light intervals. If this court were to say, you know what, we're striking down the whole red light camera program, it's gone, yellow light intervals are still the same. And a law enforcement officer standing there watching someone drive through a red light could charge them with a violation of the statutes. And so the plaintiffs here are basically requesting that the court get rid of a program that has nothing to do with their theory of the yellow light is too short. That is, again, controlled by the DOT, not the City of Greenville. The red light camera program didn't change it, didn't have anything to do with it, and this language in the statute that requires signed and sealed professional engineer, which, again, plaintiffs concede was done. It was signed and sealed by a professional engineer. The City of Greenville complied with its obligations under the statute. What they're trying to do is strike down the entire program based on this idea of the yellow light being too short, when that has nothing to do with the actual program itself. Moreover, this idea that we have some duty to enforce 89C, the city's duty, I'm not sure, Your Honors, how we would do that other than report it to the Board of Engineers, who already is aware of it and took action that they deemed appropriate. What more enforcement can the City of Greenville do?
Well, that is sort of a question I think that we have in looking at the statute is what did the General Assembly mean there?
Well, Your Honor, I can only say what it says, and it says that it can't be less than the plans by an engineer or the Manual on Uniform Traffic Control Devices. It is not less than either one of those.
Well, what I meant is the provision that your friend from the appellant argues. Yes. So if the licensure of engineers is left entirely to a state board, what does that provision mean in the statute?
That's a very good question, Your Honor, and unfortunately, I do not have the answer to that. All I know is that we have racked our brain on what enforcement we could do of 89C beyond letting the Board of Engineers know about it, and I'm not sure what that answer would be. Board of Engineers did know about it. They took the action that they deemed appropriate. That doesn't invalidate the red light camera program, because that provision of the statute that talks about a licensed engineer talks about setting of the yellow light intervals, which the city didn't do, the red light camera program didn't do.
So you think it's essentially just an odd way of saying if a public official is aware of any of this, that there's a requirement that any public official report it for appropriate discipline to the agency. It's essentially requiring some sort of reporting, because otherwise there's, at least in your position, there's nothing that anyone other than that licensing agency can do about it.
As far as I can tell you, Your Honor, because there is no private right of enforcement under 89C. Just as the plaintiff cannot sue us for a violation of 89C, we cannot sue anyone else for a violation of 89C. All we can do is refer it to the appropriate board to take whatever action they deem appropriate, which is exactly what happened in this case. And again, it has nothing to do with the red light camera program, because the red light camera program didn't change the yellow light intervals, which is really, when you get to the gist of plaintiff's complaint, you hear, oh, fast yellow, that's why he got cited. Well, that's all well and good, but that's an issue for the DOT as a matter of public policy to determine what they want the yellow light intervals to be. If plaintiff's expert is correct that these intervals are all wrong and everyone's been doing it wrong for years and years and years, that's a public policy decision that really needs to go to the DOT to change the yellow light intervals. The city has no authority to do that by itself, and the red light camera program that we're here about today simply does not change or alter the yellow light interval in any way. Like I said, if you struck this down today and said no more red light camera program, yellow light's going to be the same length. Police officer standing watching someone drive through it would have the same authority to charge that they do now. With regard to the grace period, which is another issue that the plaintiffs have raised and said, well, your grace period isn't long enough because you're catching 90% of people who drive through this light are innocent. Well, one, what does that mean? When they say 90% are innocent, what they mean is, yes, they drove through the red light, yes, they violated this provision of the statute, but they had some reason to do so. Well, one, I'm not sure where they get that 90% number. Where that comes from, I have no idea. How could any expert possibly say 90% of people who ran that red light were innocent? They should not have been charged. Unless you've seen everyone do it, unless you reviewed all the citations, that number is just made up. But with regard to the constitutional claims, which is really what we're here about, there is no constitutional right to run through a red light and not get a citation, and that's really the bottom line of this case. What they're saying is, if we had set the grace period longer, like 3 seconds or something like that is what I think they want. One, that means you could stop at the light, and if you proceed through within 3 seconds, you're not going to get a citation. As a matter of engineering, I don't know. That it's a violation of the law, I know that, and it's subject to citation.
Well, I understood, although it's an odd claim, I understood the claim your friend for the appellant's making is that every time, if you see a stop sign, you're driving along your car and you think, well, shoot, I'm driving down the road and I'm forced to stop at this stop sign. It implicates the right to travel in the 14th Amendment because you had to stop there instead of keep going. And then the question is, well, what is the standard then of constitutional scrutiny of that claim, and is the reason for the red light traffic camera laws survive that scrutiny? And so I'm curious to hear your response to what you think that test is that we are applying here and whether this survives it.
Sure. Well, fortunately, Your Honor, I think that answer has been questioned by courts previously. It is rational basis review. When looking at a $50 fine, the court said this does not fundamentally affect your right to travel. It's just a $50 fine. It's a minimal fine. It does not alter the fundamental right to travel. It's rational basis review. And we certainly have lots of grounds for this program that survive rational basis review. I'll also point out that to the extent someone drives through a light and and thinks that, you know what, I had a valid reason to do that, it was unsafe for me to not do this, that is why the appeal process is in place. And, you know, when you have the right, and Mr. King said it well, the courts have decided this issue numerous times. If you have the right to appeal, and then the right to appeal from that to Superior Court, in the nature of certiorari, where full record review, you can challenge constitutional violations below, you can challenge bias, you can challenge, you know, the whole process. That's the proper venue for a determination for someone saying, hey, I shouldn't be charged for this because it was unsafe for me to stop. Rather than the court in a hypothetical vacuum here saying, well, it could be the case that someone has the right to stop and therefore the entire program needs to be shut down because someone might run the light innocently and get a ticket. Well, that citation that you receive, again, is subject to appeal, subject to review by not only the administrative process, but by the Superior Court. And so, you know, when you're saying my procedural due process rights have been violated, you can't say that when you have the right to appeal, to go to Superior Court, to have a judge review and weigh in on these specific claims that the plaintiffs are making. He could have come in and said, you know what, I didn't get the right to record my hearing. That's a violation of my due process rights. That would have been a perfectly valid argument on an appeal to Superior Court. Unfortunately, Mr. Malmos didn't even follow that process. So he didn't get, you know, instead he just came in here and said, you know, I would like for y'all to strike down the entire red light camera program because I didn't get the right to record at my hearing. Not to mention, yes, I could have resolved that issue on an appeal. That would have protected my rights, and I could have gotten a Superior Court judge to weigh in on the record, you know, with the full record before the judge. Was this hearing appropriate or not? The court, in that case, on an appeal, could have sent it back down to the administrative hearing and said, you know what, you need to let him record. Instead, we've bypassed that whole process to come in here and say, I didn't get any procedure. I didn't get the process I was entitled to. You can't do that if you do have that process and you don't even follow it.
All right. Thank you, counsel.
Thank you, Congressman.
Rebuttal?
Thank you, Your Honor. I have 6 quick points. First two addressing Mr. King's argument. On bottom of page 5 over page 6, we address his argument about the adequate state remedy. And I just quote the Rules of Civil Procedure: an adequate state remedy does not preclude a judgment for declaratory relief. That's in the statute. Then he relies on structural components versus City of Charlotte, but that was not a declaratory judgment case at all. On page 6 of the reply to Pitt County, we raised another constitutional provision, Article 9, Section 6, which, which in addition to Article 9, Section 7, precludes Pitt County from giving money back voluntarily or involuntarily to the City of Greenville. The last sentence there, all the money that the city get must be, that the board gets shall be faithfully appropriated and used exclusively for establishing and maintaining a uniform system of free public schools. These payments of 30% to Greenville does not accomplish that purpose exclusively. 4 other quick points. Yes, correct. Greenville does not set.
So I'm sorry, and I'll give you, I don't want to eat in your time, but I do want to ask you a question about that. Suppose you're right. What's the remedy in your view?
Well, to stop them from doing it.
So a declaratory judgment saying you can't pay that 30% out because it doesn't, that's not being used exclusively for free public schools.
Yeah, on that claim, the Declaratory Judgment Act allows supplemental remedy. So if they don't stop, you could get an injunction. Okay. 4 other quick points. They're correct that Greenville doesn't set the intervals, but Greenville does control the tolerances. And the only evidence before you from an expert is that 0.3 seconds is insufficient to protect innocent drivers, whether it should be another second, 2 seconds, 3 seconds. is an interesting question, but Greenville does control that. Next question. What could Greenville do about the engineer problem? Well, they could find an engineer who would sign and seal their plans. I'd like to see the engineer who would, because that's what they could do, to answer your question. Where does the 80 to 90% come from? Well, I would encourage you to review the thorough affidavits of Mr. Ceccarelli, both the original long one and the supplemental, more concise one.
Do you agree that the level of constitutional scrutiny on this claim is rational basis?
No.
Why not?
Well, because the Supreme Court of the North Carolina has declared that the right of interstate travel is a fundamental right, and that requires a compelling interest, and a compelling interest is just not giving money to Greenville and the schools. And then finally, Your Honor asked, what's the difference between a stop sign and a stop light as far as this fundamental right to travel? When you see a stop sign, you know you're going to have to stop. When you see a stop light that's green and you're coming up upon it, you have to guess when the yellow light goes on whether you can continue at the same speed, or if you're in the dilemma zone, do you have to speed up, or if you're too close to get there before the time runs out, do you have to slam on your brakes? That's the difference. Thank you much for hearing us.
All right, thank you, counsel. I understand there's going to be a slight change of parties, but not too much of a change. So if you all stay seated for a moment, we just need to make some technical changes for the next live stream. So thank you all.